The auction was canceled and Dash is currently frantically scouting for another venue to make the sale. It's not a matter of if, only when. Welcome to Wine and Chill, your home for all things entertainment law shenanigans and legal shenanigans in general. I'm Stephanie, your friendly neighborhood lawyer. Well, as you may have forgotten, since it's been about a month since we've done a legal video, not your lawyer. Which brings me quickly to our disclaimer. By watching this video, you understand and acknowledge that this video is solely for entertainment purposes only, and you agree that you've read the full description down below in the description box. Hello. Today, we're drinking wine in a can. I just like how that sounds. Also, oh, okay. Hold on. Rosé in a can from She Can. How cheeky. It's women owned. I like it. I haven't had it yet, so let's see. It's good. I like it. Better than what I would thought. A few of you requested the Jay-Z versus Johnathan Mannion, the photographer lawsuit regarding the Reasonable Doubt cover. And because corporate is corporate and has been keeping me from my lifelong dreams, it's a smidge late. However, lateness has paid off because now Reasonable Doubt has, for some reason, spurred 20-something, almost 30 years later, 2 lawsuits. Because now Damon Dash is also being sued regarding Reasonable Doubt. So you're gonna get a twofer. We're going to do both. First, we will do the Jay-Z versus the photographer lawsuit regarding the rights to sell the pictures from Reasonable Doubt. Second, we're gonna do Roc-a-Fella versus Damon Dash because Damon Dash has decided that he owns the copyright to Reasonable Doubt. Which I have a reasonable doubt about that. I was trying to be serious. All right, so here is our agenda. Jay-Z versus John Mannion. We're gonna talk about right of publicity specifically. Going to Roc-a-Fella versus Damon Dash. We're gonna talk about NFTs, non-fungible tokens, which if you are confused how NFTs have to do with this, welcome to the party. This is gonna be an interesting one. And then we have a cameo from Jay-Z's 1995 contract between him and Roc-a-Fella. So let us begin. Jay-Z versus John Mannion, the photographer. We have 2 claims. The first is violation of section 3344 of the California Civil Code, and the second is violation of the California common law right of publicity. They're both the same things. One statutory and then one is common law. So common law means it's codified in case law. That's all common law means. Statutory means it's actually a written regulation. They're both for the same thing. So we're gonna go through right of publicity. So in right of publicity is the right of any person, famous, regular degular from the Bronx, from Brooklyn, Marcy Projects, anybody. And their right to control their image likeness, right? Not to be related to defamation. If you're a public figure, there's a different bar. Right of publicity is the same bar for everybody. So, which might bring you to ask, Stephanie, how does this work with paparazzi? The right of publicity works different with paparazzi because technically in the United States, photographs that are taken for editorial use are allowed to be enjoyed by the public under free speech. So editorial use is basically newspaper or magazine articles that gives the opinions or editors of publishers. So tabloids, for some odd reason, are still editorial use. They're not allowed to do certain things. After the tragic death of Princess Di, paparazzi can't chase people in a car. They are not allowed to use like certain lenses to zoom into your home, things like that. But if you out on the street, your right of publicity gone because it's for the good of free speech and media. I don't think us taking unflattering photos of celebs should be protected like that, a la Britney Spears documentary, but you know. Okay, cool. So with copyright law, one more thing, tenet of law for us to talk about before we get into the case. With copyright law, the photographer owns the copyright. So the author of the copyright is defined as the creator of the original expression of a work. So let's get into the lawsuit. So we're going to the photographer first. Paragraph 1, Jay-Z brings, so let me scooch over. I will link the lawsuits down below because they're online. Jay-Z brings this action to stop John Mannion from exploiting Jay-Z's name and image without Jay-Z's consent. Mannion has developed a highly profitable business by selling copies of photographs of Jay-Z on Mannion's website and retail store, and by selling licenses to others to use Jay-Z's image. Mannion has done so on the arrogant assumption that because he took those photographs, he can do with them as he pleases. But Jay-Z has never gave Mannion the right to use his likeness for these or any other purposes. Remember that. And without that permission, Mannion has no legal right to do so. Jay-Z has asked Mannion to stop, but he refuses to do so. The law that we are applying today for these claims is Section 3344 of the California Civil Code and the California Common Law regarding publicity. The California Civil Code reads in part as, any person who knowingly uses another's name, voice, signature, photograph, or likeness in any manner or in any products, merchandise, or goods, or for purposes of advertising or selling or soliciting purchasing of products, merchandise, goods, or services without such person's prior consent, shall be liable for any damages sustained by the person or persons injured as a result thereof. Very cut and dry. Did you use their face to sell your toothpaste? It rhymed better in my head. Then, the common law, very simple 4-step test, the defendant's use of plaintiff's identity. The appropriation of plaintiff's name or likeness to defendant's advantage, commercially or otherwise, lack of consent and resulting injury. So keep that in mind as we go through Johnathan Mannion's website. Here, which do we have the use of plaintiff's identity? Oh, my hair is stuck. Is Jay-Z's face, Hove, showing? It is. Okay. Appropriation of plaintiff's name, likeness to defendant's advantage, commercially or otherwise. Is this getting sold for a profit? $50? Ooh, $3,000, $4,000, $5,000. Ooh, expensive. Interesting. Okay. Lack of consent. Jay-Z said, listen, boo-boo, I did not tell you to do that. Okay. Resulting injury. Yes. Money lost. So, it would seem that this case is very clear-cut. Close the book. However, one little fact leaving out. Now, Jay-Z's saying he didn't consent. If Mannion can prove Jay-Z's consent, then one would think. Let's go through paragraph 3. Although it is bad enough that Mannion has spent years exploiting Jay-Z's image for profit without Jay-Z's permission or compensation, Mannion has now demanded that Jay-Z pay him tens of millions of dollars to put an end to Mannion's use of Jay-Z's likeness. They didn't attach any receipts for that, so we will see when Mannion responds if he actually tried to shake Jay down for that money. Let's go back into the past. Paragraph 21. Starting in 1996, Johnathan Mannion began taking hundreds of photographs of Jay-Z. Jay-Z and his record company, which is Roc-a-Fella, used some of the photographs for his album cover and paid Mannion's tens of thousands of dollars for those uses. But Jay-Z never gave Mannion permission to resell any of the images. Remember, lawsuits are just allegations. Johnathan might come back and be like, you a lie? You wrote it on this paper. Nor did Jay-Z authorize Mannion to use his name, likeness, identity, or persona for any purpose. Jay-Z was careful not to give Mannion permission to exploit Jay-Z's image in the photographs that Mannion took of Jay-Z. So let's for a second take this at face value and say, of course Hove never gave that man permission. He may not have, but did somebody else? The question actually, what I find interesting, hinges on whether Jay-Z or Roc-a-Fella gave Johnathan Mannion permission to use his image, his likeness, his publicity rights in those photos. That is actually the question. Also, good thing that there are 2 lawsuits, and one of them includes the Jay-Z Roc-a-Fella contract. So, also let me know in the comments if you'd like me to do a breakdown. I know it's been a long time since we've done a contract breakdown, and although this contract is 25 years old from 1996, it's still very interesting, and it's interesting to see the dynamics here because Jay-Z is a 1/3 owner of Roc-a-Fella. So his terms are much more favorable than, per se, Kanye's terms when we looked at Kanye's contract way back when. This Johnathan Mannion lawsuit was filed June 15th. The Roc-a-Fella versus Damon Dash lawsuit was filed June 18th. So essentially, sometimes corporate, taking up all my time and pushing my dreams outside of my reach is a good thing? Not. So let's go to section 5 of the Roc-a-Fella Jay-Z original contract. All right, section 5.01, name and likeness. We, Roc-a-Fella, and any person, firm, or corporation designated by us shall have the perpetual, forever. I always want to say it like Cardi, and I don't got that. I can't. Worldwide right to use and to permit others to use your name, both legal and professional, approved likeness, and approved biographical material concerning you for purpose of trade, promotion, advertising in connection with the LP and or masters. 5.02, you shall cooperate with us as we reasonably request in taking photographs and preparing other materials for use in promoting and publicizing you, the LP and the masters. So it's clear that Mannion is using the pictures. Check. It's, according to Jay-Z, he didn't give him permission. The only plausible defense that I could see is that Roc-a-Fella gave Mannion permission, because a lot of photographers will actually negotiate for licensing rights. They'll say like, hey, yeah, I'll take these pictures for you, but I own them and I'm giving you a license for you to use them. It's actually mine. I wouldn't be surprised. This is 25 years ago. This is Jay-Z's debut album. He just made Roc-a-Fella. Attorneys mess shit up sometimes. That might be plausible, because why for 25 years has this man been selling these photos and Jay-Z hasn't sued him? Why for 25 years has this man been so bold if he didn't know, like, hey, I have the paperwork? Confused. Keeping in mind though, for that defense to work, one little hinge in that is that Jay-Z is a 1/3 owner of Roc-a-Fella. So if I'm a 1/3 owner, I don't think that I would sell away my rights. However, who owns the other 2/3? Which brings us to our next case. Now we have Roc-a-Fella, RAF, versus Damon Dash. Let's get dramatic. The clock is ticking. Dash had planned to sell at a Super Farm Foundation online auction on June 23rd, 2021. That is, depending on when I edit this, today. The copyright to Jay-Z's debut album, Reasonable Doubt, recognized as one of the greatest recordings in history. The auction was canceled and Dash is currently frantically scouting for another venue to make the sale. It's not a matter of if, only when. Come on now, we're like 5 sentences in. Isn't this written so much more exciting than the last lawsuit, even though they're done by the same firm? I'm just saying, whoever wrote this one, like, they need to rub off on the person who wrote the other one. Or they were having 2 very different days. But Dash does not even own Reasonable Doubt or its copyright, and therefore has no right to sell the album or any rights to it. Instead, RAF Inc. owns all rights to Reasonable Doubt. That's Roc-a-Fella. The sale of this irreplaceable asset must be stopped before it's too late, and Dash must be held accountable for his theft. Woo! Very, very dramatic. All right, so when you read that, you're like, okay, Damon done stole something, but I don't know what it is. What is he auctioning? To paragraph 3 we go. Paragraph 3, during the past year, the market for non-fungible tokens, also called NFTs, has exploded. A non-fungible token is a unit of data that is minted and stored on a digital ledger called a blockchain that certifies a digital asset to be unique and therefore not interchangeable. That's actually a pretty good definition. It's still a little illegally, but it's pretty good. Simply put, it is a digital asset recorded on the blockchain that shows proof of ownership. This is assuming that blockchain is a simple thing to explain, which it is not. NFTs can be created to transfer ownership of virtually any asset, from visual art to sporting event tickets to copyrights. NFTs can be freely bought and sold like any other asset, and some NFTs have traded for tens of millions of dollars. Superfarm owns an online platform that mints and sells NFTs to the public. All right, let's take a step back. So, if you too are skeptical about the rise of NFTs, please join the club because you are not alone. Let's use a GIF as an example. This is moving form of my favorite meme, of my favorite GIF, of one of my favorite moments on reality television. It applies to almost everything, because what was the freaking reason for Damon Dash to think this was a good idea? So a non-fungible token, in layman's term, is a digital asset, often a digital image, a digital moving image, that's what a GIF is, audio file, gaming file that is assigned an origin number on the blockchain, basically. Blockchain tracks things. Super layman terms. Let me find a good video for y'all to explain blockchain. But yes, that's basically what it is. Now with NFTs, you can inherently assign the actual copyright of something. Intellectual property, it's called intellectual property because it's non-tangible. Remember, you can always have held a CD, but you can't hold music. So whoever made the GIF would own the NFTs. So if for some odd reason I finally learned how to actually use tech, even though I'm a tech attorney, yeah, it's complicated, and I were to make said GIF, if the GIF were to become an NFT, I would own the copyright to the GIF. Now, I still could violate the inherent right of publicity to Cardi B if I were then to sell said GIF. For context, in case you two are confused, child, you're not alone. The most expensive NFT is from Beeple, don't know who that is, and was for $60 million. Clearly, they are a much smarter person than I. We're not going to get into the validity or the stupidity of these new assets, but suffice to say, it's speculative at best. So what are the claims in this case? So stealing, thiefing, mobbing, and robbing, in that order. Or in legalese, conversion, replevin, breach of fiduciary duty, unjust enrichment, which essentially means what I said, in that order. Attempted sale, let's go down to paragraph 23. So, Dash attempts to auction his purported interest in the copyright to Reasonable Doubt, a company asset. Now remember, Jay-Z is not the one suing Damon Dash. Roc-a-Fella is suing Damon Dash. Paragraph 23, Dash is attempting to steal a company asset, mint it as an NFT, and auction it. Originally, he planned to use Superfarm, an electronic platform that allows people to create farm, I don't understand the farm part, buy, sell, auction, and swap NFTs. Farm, again, this is Dash's original illicit plan to auction his non-existent property interest in Reasonable Doubt is detailed in the Superfarm auction announcement. The drama in this between two middle-aged men is very funny to me. Superfarm is proud to announce in collaboration with Damon Dash the auction of Damon's ownership of the copyright to Jay-Z's first album, Reasonable Doubt. This marks a new milestone in the history of NFTs, which is not a long history, entitling the new owner to future revenue generated by this unique asset, because he's selling the actual copyright. It just happens to be minted in this digital asset. The monumental event will last for 2 days, starting on June 23rd and concluding on June 25th. Superfarm is excited to host this truly remarkable auction and immortalize one of the world's greatest artists on the blockchain. Ciao. Continue. So, why is Roc-a-Fella suing Damon Dash instead of Jay-Z suing Damon Dash? Well, simply put, Roc-a-Fella owns the copyright to Reasonable Doubt, not Jay-Z, nor Damon Dash. Paragraph 2, Sean Carter, aka Jay-Z, Kareem Burke, and Dash each own 1/3 of the shares in RAF Inc. In 1995, RAF Inc. and Jay-Z inked a record deal, that I showed you, under which RAF Inc. would own, among other things, the masters and the LP from the inception of the recording thereof and all phonograph records, and other reproductions made therefrom, together with the performances embodied therein, and all copyrights therein and thereto, excluding copyright in the underlying compositions. The copyright in the underlying compositions probably went to the writers, or into like the songwriters, throughout the world, and all renewals and extensions thereof. See Exhibit A, Section 4.01. Gotta love exhibits. After several decades, RAF Inc. remains the sole owner of the rights to Reasonable Doubt. And Exhibit A, as we referenced a few months ago in the other lawsuit, here is Jay-Z's Roc-a-Fella contract from 1995. Love when complaints include exhibits. All right, I won't read you the whole thing, but I'll put it here for you. I'll just put it on the whole screenshot because it's a lot. Paragraph 4.01, rights and recordings as between artists, because you know, they're always artists, and company, all masters embodied on the LP and all masters recorded hereunder from the inception of the recording thereof shall, for purposes of copyright law, be deemed works for hire for us by you. As in Jay-Z was hired by RAF, but he also owns an interest in RAF, this is an interesting setup compared to the other record label artist agreements that we've looked at, aka Kanye. And all other persons rendering services in connection with those masters are our employees for hire. the masters and the LP from the inception of the recording thereof, and all phonograph records and all other reproductions made therefrom, together with the performances body therein, and all copyrights therein and thereto, excluding the copyright and underlying compositions, we shall accordingly have the exclusive right to obtain registration of copyright in all renewals and extensions in those masters and the LP in our name as the owner and author thereof. Now, we have said this now a few times. Damon Dash, though, owns 1/3 of RAF. So, does he own 1/3 of Reasonable Doubt? According to corporate law, no. Ownership of Reasonable Doubt. Paragraph 19. RAF Inc. was incorporated in January 8th, 1996. Jay-Z, Burke, and Dash each own 1/3 of the shares of RAF Inc. The shares are not publicly traded. These are also super expensive. RAF Inc. owns the copyright and all rights, titles, and interests to and in Reasonable Doubt, including without limitation, right to sell, record, reproduce, broadcast, transmit, exhibit, distribute, advertise, and exploit the album. Selling an NFT is distribution, exploitation, reproduction, broadcasting, transmission, and exhibition. Dash holds no individual ownership interest in Reasonable Doubt, including in its copyright. Explained further in paragraph 5. Paragraph 5. But again, Dash does not own Reasonable Doubt or the rights he is unlawfully seeking to sell. And Dash's status as a minority shareholder in RAF Inc., they're technically all minority shareholders because none of them can be the majority since it's even, gives him no right to sell a company asset. A basic tenet of New York corporate law is that the corporation and its shareholders are distinct entities. An individual shareholder like Dash does not own the corporation's assets. Only the corporation does, and an individual shareholder cannot sell, transfer, or otherwise encumber a corporate asset. If, for some odd twist of fate, I owned 50% of the shares to Apple, and therefore, would I therefore own 50% of the Apple office spaces to then treat as my house? No. I would own 50% of the money's made, of the revenue. That's it. Paragraph 6, and it's the last one. The bottom line is simple. Dash can't sell what he doesn't own. By attempting such a sale, Dash has converted a corporate asset and has breached his fiduciary duties. His planned auction of Reasonable Doubt would result in irreparable harm. The court should stop Dash from attempting to sell the copyright to Reasonable Doubt, require Dash to return the NFT of Reasonable Doubt to RAF Inc., and hold him accountable for his brazen theft of RAF Inc.'s most prized asset. So that's the case, y'all. So I think it's interesting that they asked for him to give the NFT back, which, what is the legitimacy of NFTs? Do y'all know more about, I kind of am curious. The very, very basic research I did on NFTs, I still was not convinced that this is something sustainable. I'm still not convinced. So would be curious as to your thought on NFTs. Yeah, I think the John Mannion case will get farther than this Damon Dash case. Because them asking for it back, he could just destroy it. I don't think he's gonna be able to sell this. However, John Mannion might have some receipts to pull up. I'm very curious because to be that bold for 25 years, he knows something. Or he's a bold person. Either or is very interesting. Who knew a 25-year-old debut album could cause such ruckus in this NYC summer? Well, as usual, thank you for watching. Let me know your thoughts. I would love to learn more about NFTs. So if you have any good videos about NFTs, let me know in the comments. I am just curious. Learning is constant. So let me know in the comments if you'd like to see the Jay-Z contract. We can do that. We haven't done one of those in a while. Also, thank you to my patrons, specifically the Sancerre and Champagne Tears. I appreciate you. If you guys would like to see my new series, Colonizer Exposed, head over to my Patreon. The link is in the description. I'll catch you guys tomorrow at 7 p.m. Eastern in the live. Remember, the lives are always on Thursdays. I think we are gonna do the Smile Direct case. Somebody asked for it, a few people have asked for it, and it's just kind of wild. People's teeth are falling out, allegedly. So if you haven't already, go ahead and like and subscribe, and I'll see you in the next video.